Admission to the bar in the United States is a granting of permission by a particular court system to a lawyer to practice law in the jurisdiction. Hello friends, welcome back to the channel. Before moving ahead, like, share, subscribe and don't forget to press the bell icon. Each United States and jurisdiction, that is territory under federal control, has its own country system or a court system and set its own rule and standard for bar admission. In most cases, a person is admitted or called to the bar of the highest court in the jurisdiction and is thereby authorized to the practice law in the jurisdiction. Federal court, although often overlapped in admission requirement with states, including additional step for admission. Typically, lawyers seeking admission to the bar of one of the United States must earn a Juris Doctor degree from a law school approved by the jurisdiction, pass a bar exam and professionally responsible exam, and undergo a character and fitness evaluation with some exception to each requirement. A lawyer admitted in one state is not automatically allowed to practice in any other state. Some states have reciprocal agreement that allow attorney from one state to practice without sitting from another bar exam. The first bar exam is what now the United States were instituted by Delaware Colony in 1763 as an oral exam before a judge. Many other American colonies soon followed suit. In the early United States, most state requirement for bar admission included a period of study under a lawyer or judge, a practice called reading the law, and a brief examination. Examinations were generally oral and applicable were sometimes exempted from the examination if they had cleared in a law office for a certain number of years. During the 19th century, admission requirement became lower in many states. Most states continued to require both apprenticeship and examination, but this apprenticeship become shorter and examination generally brief and casual. After 1870, law schools began to emerge across the United States as an alternative to apprenticeship. This rise was accompanied by the practice of diploma privilege, wherein graduates of law school received automatic admission to the bar. Diploma privilege reached its peak between 1879 and 1921. In most states, diploma privilege only applied to those who has graduated law school in the state when they practiced. Examination continued to exist during this period as a requirement for those in eligibility for diploma privilege and were often administered by committees of attorneys. Between 1890s and 1920, most states replaced oral examination with written bar examination. Written examination became commonplace as lawyers began to practice in states other than those where they were trained. In 1921, the American Bar Association formally expressed a preference for required written bar examination in place of diploma privilege for law school graduates. In subsequent decade, the prevalence of diploma privilege declined deeply. By 1948, only 13 law schools in 9 states retained diploma privilege. By 1980, only Mississippi, Montana, South Dakota, West Virginia, and Wisconsin honored diploma privilege. As of 2020, only Wisconsin allows JD graduate of accredited law school to seek admission to the state bar without passing a bar examination.